Trump's defense team is expected to rest its case today in this final stretch of his historic criminal hush money trial. Before entering the courtroom, Trump spoke to the camera saying prosecutors have no case and that no crime has been committed. Today, Robert Costello, a lawyer who once advised Trump's former fixer Michael Cohen, will return to the stand after a dramatic day of testimony yesterday. The judge at one point was so angry, he cleared out the courtroom. ABC News senior investigative correspondent Aaron Katersky joins me now from outside court, along with ABC News senior reporter Catherine Falders and ABC News legal contributor Brian Buckmeyer for more. Aaron, let's start with what we can expect today. Bob Costello is on the stand. Will be on the stand. What is he expected to get into today?
Yeah, the judge just took his place at the bench, Diane. We expect that Robert Costello will return to the witness stand any moment now for, I don't know, half hour, 45 minutes left of cross-examination by Assistant District Attorney Susan Hoffinger, who is going to try and question his account of meeting with Michael Cohen right after the feds raided Cohen's home and office in 2018 when Costello described...
What's up, folks? Dr. John Podcast is back in a packed New York courtroom. Trump witness Robert Costello treated his testimony like a political monologue, giving long, editorialized answers and commentary beyond what was asked, while prosecutors objected and Judge Merchan sustained them repeatedly. The clash revealed the judicial system's refusal to let Trump's inner circle turn serious legal proceedings into campaign theater. Now here's where things got really interesting. Most witnesses, when a judge sustains an objection against them, simply accept the ruling and move on. They understand that judges have authority and that arguing with that authority is a losing battle. But Costello apparently didn't get that memo. He started sighing dramatically into the microphone like a teenager who just got told to clean their room. He muttered "geez" loud enough for everyone in the courtroom to hear. He whispered "ridiculous" under his breath when rulings went against him. And then he escalated to something far more alarming.
Cohen is manic and suicidal. Hoffinger said, "You called him a drama queen, didn't you?" And Costello conceded that he did. And what the circumstances were of that meeting are kind of in doubt. Cohen said that he felt pressured to come into the fold because Costello was close with Rudy Giuliani, who was about to join Trump's legal team. And Costello said he didn't even want Cohen as a client. But there was the email to his son about how he landed Cohen as a client. It was all very confusing, and we know that Cohen has some truth issues here. So the prosecutors are going to do what they can with him, and then that should be it for the defense. They'll rest their case in all likelihood with no testimony from Trump himself.
Catherine, Donald Trump Jr. is in court with his father today for the first time, along with a number of Republican lawmakers in Trump's entourage. How significant is that?
I'm not totally surprised by that. We know that Trump's sons have been in court. Don Jr., this is his first time there. Of course, we've seen Eric Trump in court. So I'm not totally surprised by that, but I think it's definitely a continuation of this support.
He started glaring at the judge, not just a quick glance of frustration, but full-on staring matches. He gave Merchan what witnesses described as serious side-eye. He rolled his eyes like a petulant child who wasn't getting his way. Here was a grown man, a lawyer no less, who apparently thought he could intimidate a federal judge through sheer force of hostile body language. It was absolutely extraordinary to witness, and Judge Merchan had seen more than enough. What happened next was the kind of courtroom drama that makes legal history. Judge Merchan made a decision that left everyone in that room stunned. He ordered the entire courtroom cleared of journalists. Think about that for a second. Judges almost never do this. The whole point of our legal system is transparency.
That the former president wants in the courtroom. Obviously, we haven't seen Melania Trump at all. She has been essentially invisible from this trial, but in terms of the family. But then you see the group there. That's the group today walking in, the new group of supporters, if you will. And I think it just represents really how Trump is trying to bring the campaign to the courthouse. He said that publicly. He said he can't be out on the campaign trail, so why not bring his supporters and most adamant, members of Congress who are supporting him to the courthouse. So this is his entourage for the day, and we will continue to see that throughout the trial.
Brian, what do you make of Bob Costello's testimony so far, the impact for the defense here? And that moment with the judge yesterday where the judge cleared the courtroom and threatened to remove him from the witness stand.
Yeah, so impact, I think outside of theatrics, it might have been to some degree beneficial for the defense because it gave them an alternative theory. It gave them this idea that they can argue that Michael Cohen may have been telling Bob Costello the truth, that he did not have anything on Donald Trump, and that he's lying not for the safety or to help.
Open proceedings, public accountability. But Mershon recognized that the situation had spiraled to a point where normal procedures simply weren't cutting it. He needed to deliver a message to Costello without the circus atmosphere that cameras and reporters inevitably bring. With the journalists ushered out and only essential personnel remaining, Judge Mershon turned his full attention to Costello. The room was deathly quiet. You could have heard a pin drop. And then the judge spoke words that would echo through every Trump legal proceeding from that moment forward. He told Costello in no uncertain terms that his conduct was contemptuous right at that very moment. He put him on formal notice that the contempt was being officially noted and documented, and then came the threat that made Costello's blood run cold.
Donald Trump, but that he was telling the truth in an opportunity where he could have told an attorney, I've got dirt on Trump, use this for the SDNY to help me. However, the way that he performed in front of the jury, and luckily the judge pulled the jury out before they saw the real fireworks. I think that could harm him in the sense of one more outburst and the judge is already threatened. Hold his actions as contemptuous and throw out his entire testimony. I don't think any defense attorney is happy about that. And they're worried, if anything, that Bob Costello could go on another tangent that could have him running afoul with court rules.
In terms of the testimony itself, he is saying Michael Cohen told him before this trial ever started that he had nothing on Trump and that Trump didn't know about Stormy Daniels, this payment to Stormy Daniels. So how is the prosecution now going to respond to that?
So the prosecution already had Michael Cohen testify to some degree about this conversation, that Michael Cohen was somewhat hesitant of Bob Costello's relationship with Rudy Giuliani, and that this was more of a testing of the waters, so to speak, to see what Rudy Giuliani might have known and how this investigation was going about, and also to see whether or not Donald Trump was protecting him. So the prosecution can go that route of saying, yes, Michael Cohen might have told you X, but you don't know what he's thinking, which is Y, and Michael Cohen did testify to that. And so I think that's where the prosecution may go through their cross-examination of Bob Costello, which I say should last about 30 to 45 minutes.
And Aaron, yesterday, the defense also made a motion to dismiss, saying there's no evidence that the records in question here or the filings in questions here were falsified. That is the prosecution's case. The judge hasn't ruled on that yet. What's the latest?
Mershon warned that if Costello tried to stare him down one more time, just one more time, he would be removed from the witness stand immediately. And not just removed. The judge threatened to strike his entire testimony from the record. Every word he had spoken, every answer he had given, every attempt to undermine Cohen's credibility, all of it, erased, like it never happened. The defense's star witness would contribute absolutely nothing to the case. It would be as if Costello had never set foot in that courtroom at all. Now think about what that threat actually meant for Trump's defense team. They had brought Costello in specifically to create reasonable doubt. His testimony was supposed to be a crucial component of their strategy. And here was the judge ready to nuke that entire strategy from orbit if Costello didn't immediately change his behavior. That's a nuclear option for any defense team. And Mershon was holding his finger right over the button. He wasn't bluffing. He wasn't making idle threats. He was making absolutely clear that whatever tactics work for Trump in political settings would not work in his courtroom. But the judge didn't stop there. He got specific about exactly what behaviors he would not tolerate. He told Costello flat out, "You don't say geez. You don't give me side eye. You don't roll your eyes." These might sound like minor things, the kind of petty gestures people make every day without thinking. But in a courtroom, they represent something far more serious. They're a direct challenge to judicial authority. When a witness sighs loudly after a judge's ruling, they're signaling that they don't accept that ruling. When they mutter insults, they're showing contempt for the legal process. When they try to stare down a judge, they're attempting to intimidate the one person in the room who's supposed to maintain complete control over the proceedings. Judge Mershon was drawing a very clear line in the sand. He was telling Costello and everyone watching that the usual Trump playbook of intimidation, theatrical performance, and refusal to accept constraints would not work. in his courtroom. This was a new ballgame with different rules, and Costello was about to learn that lesson the hard way if he didn't get himself together immediately. This wasn't even an isolated incident. In Trump's separate civil fraud trial in New York, Judge Arthur Engoron faced remarkably similar problems when Trump himself took the stand. The former president simply couldn't stop himself from turning his testimony into a political speech. Questions that called for simple, straightforward answers somehow always morphed into long-winded monologues about how unfair the case was, how persecuted he was by Democrats, how successful his businesses had always been. It was like watching someone deliver a campaign rally from the witness stand. Judge Engoron had to constantly sustain objections and repeatedly remind Trump to just answer the questions without all the speeches and commentary. At one particularly frustrating moment, the judge called Trump a broken record because he kept reverting to the same tired talking points no matter how many times he was told to stop. Two different judges in two different cases, both having to constantly shut down attempts by Trump and his allies to turn judicial proceedings into something else entirely. Now let's be really clear about what's happening here. The pattern that's emerging across Trump's various legal battles is unmistakable and deeply troubling. He and his allies consistently try to bring their usual political tactics into courtrooms. The intimidation, the theatrical performances, the refusal to accept rules they don't like, the treatment of every moment as an opportunity for political messaging rather than legal proceedings. And judges across multiple cases keep responding the same way. They sustain objections, they issue contempt warnings, they threaten to strike testimony, they clear courtrooms to deliver stern warnings, they make absolutely clear that this behavior will not be tolerated. Inside the legal system, Trump's normal approach doesn't work the same way it works in politics. You can't intimidate a federal judge the way you intimidate a political opponent. You can't bully your way through objections the way you bully your way through media interviews. The courtroom has actual rules with actual enforcement mechanisms, and judges have actual power to impose actual consequences. What we're watching is a fundamental clash between Trump's approach to conflict and the reality of how American courts actually function. The significance of what happened with Costello goes far beyond that one courtroom on that one day. It's a perfect illustration of the dynamic that's playing out across Trump's entire legal situation. His team brings chaos and confrontation. Judges respond with order and enforcement. Trump's side screams persecution. Everyone else sees a defendant and his allies who simply can't accept that the same rules apply to them as to everyone else. And the judges keep winning these confrontations because they have the authority, the tools, and the willingness to enforce their rulings. Let's really dig into what was happening with Robert Costello, because this wasn't just about one witness having a bad day in court. This was a perfect storm of arrogance, miscalculation, and the kind of courtroom theater that makes legal history. Costello came into that proceeding with a specific job to do. The defense needed him to dismantle Michael Cohen's credibility piece by piece, to expose inconsistencies and contradictions that would plant reasonable doubt in the jurors' minds. On paper, it was sound legal strategy. Attack the prosecution's star witness and watch their case crumble. But somewhere between the planning and the execution, things went spectacularly wrong. The trouble started almost immediately when Costello took the stand. Instead of providing crisp, focused answers to the questions he was being asked, he launched into these expansive narratives that covered everything except what the prosecutor actually wanted to know. It was like watching someone give a TED Talk when they'd been asked for a simple yes or no. Prosecutors, doing exactly what prosecutors are supposed to do, kept objecting, and Judge Merchan, doing exactly what judges are supposed to do, kept sustaining those objections. This is completely normal courtroom procedure. When a witness goes beyond the scope of the question, the other side objects. When that objection has merit, the judge sustains it, and then the witness is supposed to confine their answer to what was actually asked. Simple, straightforward, routine. But Costello apparently didn't want to accept that framework. He wanted to control the narrative, to get his version of events into the record regardless of what anyone asked him. And when the judge wouldn't let him do that, he responded with increasing hostility and disrespect. The sighs into the microphone were just the beginning. They were theatrical expressions of exasperation designed to let everyone in the courtroom know that he disagreed with the judge's rulings. Then came the muttered comments that everyone could hear. Geez. Ridiculous. He wasn't even trying to hide his contempt anymore. He was performing it for everyone to see. Here's the thing about courtrooms that people like Costello seem to forget. They're not political arenas where you can argue your way past inconvenient facts. They're not media appearances where you can control the narrative through sheer force of personality. They're legal proceedings with established rules and clear boundaries. And the judge, not the witness, controls what happens within those boundaries. When Costello started giving the judge side-eye and rolling his eyes and trying to stare him down, he wasn't just being rude. He was engaged in a direct challenge to judicial authority. He was saying through his body language that he didn't accept the judge's control over the proceedings. It was intimidation, pure and simple. And it's the kind of intimidation tactic that might actually work in other contexts. In business negotiations, staring someone down might give you leverage. In political settings, projecting confidence through hostile body language might intimidate opponents. But courtrooms don't work that way. Judges have actual power to sanction contemptuous behavior, and they're not afraid to use it. Costello apparently thought he could intimidate Merchan into backing off, and he couldn't have been more wrong about that assessment. Judge Merchan's decision to clear the courtroom before delivering his warning was itself a powerful statement. Normally, judges handle witness problems right out in the open with everyone watching. The whole point of the legal system is transparency, after all. But Merchan recognized that the normal procedures weren't adequate for this situation. He needed to deliver a message to Costello without the circus atmosphere that cameras and reporters would inevitably create. So he cleared the room, brought Costello to attention in the empty courtroom, and made absolutely clear that the games were over. When journalists were finally allowed back into the courtroom, they learned just how serious the situation had become. The judge had explicitly warned Costello that his conduct was contemptuous. He had put him on formal notice that continued defiance would result in his removal from the stand. And most devastatingly, he had threatened to strike all of Costello's testimony from the record entirely. This wasn't a slap on the wrist. This was a sledgehammer being held over the defense's entire case. Think about what it would have meant if Merchan had actually followed through on that threat. Every word Costello had spoken would have been erased. The defense's star witness would have contributed absolutely nothing to the case. All that preparation, all those hours of testimony, all that effort to undermine Cohen's credibility would have been for nothing. It would have been a catastrophic blow to Trump's defense, and Merchan was prepared to deliver that blow if Costello didn't get himself together immediately. The specific behaviors that Merchan called out might seem trivial to someone who's never been in a courtroom, saying geez, giving side-eye, rolling eyes. These are things people do every day without thinking about them. But in a courtroom, they're serious matters. When witnesses start editorializing and sighing and glaring, they're undermining the judge's authority in ways that can spread and infect the entire proceeding. If one witness can get away with it, others will try. If defendants and their allies can intimidate judges through hostile body language, the whole system of judicial control breaks down. Merchan was drawing a line not just for Costello, but for anyone who might think similar tactics would be tolerated in his courtroom. The parallel situation in Judge Engoron's civil fraud trial shows that this wasn't a one-time problem with one difficult witness. It's a pattern that's directly connected to Trump himself. When Trump took the stand in that case, he simply couldn't help turning his testimony into a political speech. Questions that asked for specific factual answers somehow always morphed into long digressions about how unfair the case was, how successful his businesses had been, how persecuted he was by Democratic prosecutors. It was like he physically couldn't stop himself from giving campaign speeches even when his legal team was begging him to just answer the damn questions. Judge Engoron had to constantly sustain objections and repeatedly tell Trump to just answer the questions without the speeches. At one point, he called Trump a broken record because the pattern kept repeating no matter how many times he intervened. The broken record comment captures something essential about Trump's relationship with courtroom procedures. He has a set of talking points and narratives that he deploys in every context: political rallies, media interviews, social media posts, and apparently witness testimony. The problem is that courtrooms don't work like those other venues. Witnesses are supposed to answer the specific questions they're asked, not deliver stump speeches about their general grievances. Judges like Engoron, who enforce these rules, aren't doing anything unusual. They're doing exactly what judges are supposed to do. But Trump experiences these normal constraints as persecution because he's simply not accustomed to anyone actually enforcing rules against him. For decades, he's been able to bully, intimidate, and negotiate his way out of consequences. Courtrooms are different. The rules apply equally to everyone, and judges have the power and willingness to enforce them. The sustained objections across both trials reflect prosecutors doing their job of keeping testimony within proper bounds, and judges doing their job of ruling on those objections fairly. When objection after objection gets sustained, it usually means the witness is repeatedly trying to go beyond what's appropriate. Trump's allies have tried to frame these sustained objections as evidence of judicial bias. The judge is always siding with the prosecution, they claim. But that interpretation ignores the reality that the objections were sustained because the testimony was genuinely objectionable. If Costello had answered questions directly without editorializing, there would have been nothing to object to. If Trump had provided concise, factual responses instead of speeches, the objections wouldn't have been necessary. The contempt warnings that emerged from these confrontations connect to a broader pattern of judges threatening serious sanctions against Trump and his allies. Merchan's warning to Costello about contemptuous conduct mirrors his warnings to Trump about gag order violations. Engoron's threats of serious sanctions in the civil case followed the same pattern. Multiple judges are reaching the same conclusion. Trump and the people around him don't accept normal constraints, and escalating warnings are necessary to maintain courtroom order. This isn't bias. It's judges responding appropriately to defendants and witnesses who refuse to play by the rules everyone else follows. Let's pull everything together now and really understand what these courtroom confrontations mean for Trump's legal situation and for the broader question of whether he and his allies can ever accept the constraints that apply to everyone else in the legal system. We've now seen across multiple trials and multiple judges a consistent and troubling pattern. Trump's team tries to bring their usual tactics into courtrooms: intimidation, theatrical performance, refusal to accept constraints, treating every moment as an opportunity for political messaging rather than legal proceedings. And judges consistently shut them down with sustained objections, contempt warnings, threats of sanctions, and extraordinary procedural moves like clearing courtrooms to deliver stern warnings. The Costello incident perfectly encapsulates this entire dynamic. Here was a witness who came to court apparently thinking he could perform rather than testify. When the judge sustained objections and enforced normal rules about answering questions directly, Costello responded with sighs and eye rolls and staring matches, the kind of contemptuous behavior that would get any other witness sanctioned immediately. Judge Merchan had to take the extraordinary step of clearing the courtroom and explicitly warning Costello that his conduct was contemptuous and that continued defiance would result in removal and the striking of all his testimony. A defense witness nearly destroyed his own side's case because he couldn't accept that courtroom rules applied to him. Trump's own testimony in the civil fraud trial showed the same fundamental problem. He couldn't stop giving speeches when judges and procedures required him to answer questions directly. He kept reverting to political talking points even when told repeatedly to just respond to what was asked. Judge Engoron had to sustain objection after objection and eventually resorted to calling Trump a broken record because nothing seemed to get through. A defendant who simply answered questions truthfully and concisely would have had a much easier time on the stand. But Trump apparently can't operate that way. Everything becomes a performance. Every moment becomes an opportunity for his usual rhetoric. The pattern of sustained objections across Trump's cases reflects reality, not bias. Objections get sustained when testimony is objectionable, when witnesses go beyond the questions, when answers include improper material, when courtroom rules are being violated. If Trump and his allies weren't constantly pushing boundaries and trying to turn testimony into speeches, there would be far fewer objections to sustain. Judges aren't manufacturing reasons to rule against Trump. They're responding to conduct that genuinely violates the norms that apply to everyone in legal proceedings. Here's what's truly significant about these confrontations and why they matter beyond the specific cases. They demonstrate that Trump's usual tactics have limits. In political settings, Trump can intimidate opponents, dominate media coverage, and refuse to accept rules he doesn't like without immediate consequences. But courtrooms are fundamentally different. Judges have actual power to enforce rules. Contempt findings and sanctions are real consequences with real impact. Testimony can be struck. Witnesses can be removed. The confrontational approach that works for Trump elsewhere becomes counterproductive when applied to judges who won't be intimidated and who have the tools to respond to defiance. The contempt warnings that multiple judges have issued against Trump and his allies represent a consistent judicial conclusion that normal constraints aren't being respected. Merchan warning Costello about contemptuous conduct. Merchan warning Trump about gag order violations. Engoron threatening serious sanctions for attacks on court staff. Different judges and different cases reaching the same conclusion. Something about how Trump's side operates requires explicit warnings about consequences that would rarely need to be stated to other litigants. The common denominator isn't biased judges. It's a defendant and his allies who don't accept that rules apply to them. The threat to strike Costello's entire testimony if he didn't stop his contemptuous behavior shows how far judges are willing to go when pushed. That would have been a devastating blow to Trump's defense. Their star witness contributing nothing because he couldn't control his attitude toward the judge. Merchan was prepared to impose that sanction if Costello continued. The only reason it didn't happen is that Costello apparently got the message and modified his behavior enough to avoid removal. But the willingness to go there shows that judges aren't bluffing when they issue these warnings. They're prepared to follow through with serious consequences if necessary. The political implications of these courtroom confrontations cut both ways. Trump supporters see judges sustaining objections and issuing contempt warnings as evidence of the persecution narrative, proof that the system is rigged against him. They share clips of these moments on social media, use them to rally the base, and reinforce the message that Trump is being unfairly targeted by a corrupt legal establishment. But outside Trump's base, these incidents reinforce a very different narrative. They show that Trump and his allies can't follow basic rules, that they treat every setting as an opportunity for confrontation and performance, that they don't respect institutions that don't defer to them. The image of a judge telling a witness, "You don't say geez and you don't give me side-eye," is incredibly powerful. It undermines Trump's claim to be defending the rule of law. It shows that he and his allies treat courtrooms with the same contempt they treat everything else. And it demonstrates that judges, at least, are willing to stand up to that contempt and enforce the rules that apply to everyone. The question going forward is whether Trump and his allies can ever adapt to courtroom realities, or whether they'll continue bringing their usual tactics into legal proceedings and facing the consequences. The evidence so far suggests adaptation is unlikely. Trump has been involved in litigation for decades and shows no sign of having learned how to be a normal litigant who follows rules and respects judicial authority. His allies like Costello apparently absorb the same approach and bring it into proceedings where it creates problems. The confrontational style is so deeply embedded that it emerges even when cooperation would serve their interests better. The ongoing legal battles will continue to produce these courtroom confrontations because the underlying dynamic isn't going to change. Trump will keep pushing boundaries. His allies will keep trying to turn testimony into performance. Judges will keep sustaining objections and issuing warnings and threatening sanctions. The clash between Trump's world and judicial reality is structural. It's built into who he is and how he operates. Courts will keep shutting him down, and he'll keep framing that as persecution rather than accepting that the same rules apply to him as to everyone else. The Costello incident, courtroom clearings, contempt warnings, and the refusal to accept that rules apply exposes a fundamental question: whether the rule of law still means something in America, or whether the legal system is just another venue for political performance. Judges across the country are increasingly making clear that whatever works for Trump in politics doesn't work in a courtroom where consequences are real, and the system is pushing back. But whether it can push back hard enough to maintain its integrity remains an open question.